So I guess we'll get started as folks continue to wander in from class. I'm Dory Bernstein. I direct the Supreme Court Institute here at Georgetown, and on behalf of Executive Director Irv Gorenstein and Assistant Director Sarah Naiman, we are happy to welcome all of you here to what promises to be a very interesting discussion of the pending nomination to the U.S. Supreme Court. I'll introduce our moderator, Adam Liptak, who is the Supreme Court correspondent for what I like to call the New York Times purveyor of genuine news. And he will introduce our other panelists and take it away. Thank you all for being here.
Thank you, Dory. Others call it the failing New York Times. So I see in our flyer that we've promised you an engaging roundtable of experts. The roundtable metaphorical, apparently. The expertise real, and the engaging we'll find out. I'm going to introduce the panelists and then talk a little bit about the format and then get underway. So to my right is Shai Dvoretsky, who's a partner at Jones Day, where I'm guessing he now wanders the empty hallways looking for his colleagues, all of whom have joined the Trump administration. He's a graduate of Yale Law School, a former law clerk to Justice Scalia, and has argued numerous cases before the Supreme Court. Thank you. To his right is Caroline Fredrickson, president of the American Constitution Society. She's a graduate of Columbia Law School and has worked also at the ACLU and NARAL Pro-Choice America. Then Christine Lucius, who's a graduate of Georgetown Law and has served most recently as chief as chief counsel of the Judiciary Committee, spending the last 10 years working for Senator Patrick Leahy in a variety of counsel roles. And in that capacity, and I'll quiz her on this a little bit, Christine was actively involved in the confirmation processes for half the current occupants of the court. It's an even number, Roberts, Alito, Sotomayor, and Kagan. Next down the line is Ed Whalen, who's president of the Ethics and Public Policy Center, a must-read blogger at the National Review Online's Bench Memos blog. He's a graduate of Harvard Law School and also is a former law clerk to Justice Scalia. And finally, Elizabeth Wydra, president of the Constitutional Accountability Center. Elizabeth is a graduate of Yale Law School and used to work at the Quinn Emanuel firm. So what I'd like to do here is not have the traditional kind of panel where people give little 10-minute canned speeches, but have more of an interactive conversation. It's such a lively topic. And I've urged people not to wait for questions from me, but if they hear things they want to react to jump in. I think we'll have three little chapters, one kind of backward looking at earlier confirmation hearings and the Garland nomination, and ask whether that casts any kind of shadow over the Gorsuch nomination or whether we should consign all of that to history. A more substantial piece of the discussion about Judge Gorsuch himself, and then maybe look forward a little bit to what the court would look like if Judge Gorsuch is confirmed and what other vacancies might be on the horizon. I thought maybe the best way to start is to start with Christine, who's had rolled up her sleeves and really looked at the past several confirmations, and just give us the briefest of overview of how these last four worked, whether there were distinctive characteristics among them or whether they were all more or less the same, where the nominee received some amount of critique from the opposition parties, some amount of negative votes, but fairly smoothly sailed onto the court, and whether the Garland experience changes things at all.
Thank you so much. It's great to be back here at Georgetown. When I walked in this afternoon, I had this deja vu feeling of having not done my Fed Courts reading yet. So hopefully my public speaking will get easier than this opening being on call. I actually have worked on the past 6 nominees to the Supreme Court, 4 of whom were confirmed. That's how I view it. I worked very hard on Harriet Meyer's nomination before she withdrew. Her hearing was scheduled, and there was some really interesting moments in that. And then last year, the Merrick Garland nomination. So To answer one of your questions, I do think that the experience of last year, which included Merrick Garland, but there were also many other unique things about what happened with regard to the confirmation process and the consideration of Supreme Court nominees in 2016, I do think that is going to have an impact on how people consider Supreme Court nominees going forward. It really was something that I never would have predicted. I've worked for Senator Leahy for more than 14 years, and I think even he, the most senior senator serving in the U.S. Senate, was surprised at all the different things that happened in 2016, one of the biggest moments of which was the majority leader announcing that no consideration would be given to the president's nominee to the Supreme Court. So of the four that went through, there were some unpredictable moments. I wouldn't say that any Supreme Court process is necessarily predictable. These are real people who have interesting backgrounds. There's a lot of attention, and more so, there's a lot of money that gets involved in advocacy groups for and against. Each senator has his or her own standard and approach to how they consider nominees to the lower courts and especially the Supreme Court. But Senator Leahy would often remark that the Supreme Court hearings are this rare public moment where people pay attention to the Supreme Court in a different way. It's just the most transparent time. It's a time to make sure that the American people understand how the Supreme Court decisions affect their everyday lives. We lawyers care a great deal about the court, and we read SCOTUS blog every day, and we know the minutia of who's filing an amicus brief, but that's not how most Americans, follow the third branch. So those public hearings that are coming later this month are really an important moment, and in each of the four that I worked on, I was really impressed by how seriously the senators took the process and how seriously the nominees took the process of preparing for the public hearings, of taking it very seriously, and then coming to their decision. But as you notice with the confirmation votes, there was serious opposition for all four of the most recent confirmations. They were not confirmed 99-0, as they may have been in a previous generation. Because, frankly, there's just been more focus from the political branches on the importance of each individual who serves on the one branch that's supposed to be above politics. So I do think that in none of the four would I have said it was a cakewalk. I think that each one presented its own challenges for the nominee and for the people trying to learn about what was really behind the nominee.
Elizabeth, let me ask you about Judge Garland, who didn't get a hearing. Maybe a two-part question. Anything wrong with that? Did that violate any legal or other norm? And does it cast a shadow? Should we think about Judge Gorsuch differently in light of what happened to Judge Garland?
Thank you, Adam. First, before I get to those two questions, which are great, I just want to thank everyone for being here and thank the sponsors for inviting me. I spent 2 wonderful years at Georgetown as a teaching fellow, supervising attorney in the Appellate Litigation Clinic, and so it's really great to be back. I think the answer to your first question about did what happened to Chief Judge Merrick Garland violate constitutional norms or other institutional norms? Absolutely. I think there are, as Christine said, important reasons to consider the Supreme Court, at least aspirationally, above politics. Chief Justice Roberts has repeatedly said that he doesn't consider the court to do their work as Democrats and Republicans, but rather as justices who surely have their ideologies, but they don't view themselves as political in the same way, and that it is detrimental to the court to view them that way. I certainly agree with that, even though sometimes it might appear as if they are acting in a political way. We certainly don't want them to, and I agree with Chief Justice Roberts on that point. Here you had almost a full year left in President Obama's term. He put forth this nominee who even Republican senators said is the person that they would hope Obama would pick, but he won't. And then he did. And Merrick Garland is someone who would have easily gotten bipartisan support if he had been ever put through the process properly. And I think that is certainly not the way simply saying we're not going to consider this president's nominee when he has a full term left in his term. He's under the Constitution president up until the last day of his term. Maybe we might have a slightly different conversation if it was a week before he was out of office, but we had an entire year left in his term, and the important business of the Supreme Court to consider. I thought we needed 9 justices then. I still think we need 9 justices. Some people say, well, liberals are going to change their mind now. No, I'm not. I think we need a fully functioning Supreme Court with a full complement of justices. That doesn't mean you put anyone up there, but I do think it's important. So the fact that the Senate, to me, did not fulfill what I consider to be their proper advice and consent role under the Constitution after the president fulfilled his right to put forth a nominee, and a really incredible nominee at that. I think both flouted constitutional norms as well as institutional norms that are broken down in the Senate, unfortunately. I guess that leads me to your second question, whether that casts a shadow over Gorsuch. It clearly does for some participants in the process. And, I can certainly see why people would view it as a stolen seat. My feeling is I want to take advantage of the moment, as Christine said, this rare moment to talk about the Supreme Court, the meaning of the Constitution, in a moment when the American public is really paying attention more than we often do. So, from my perspective, I want to engage in that fight and talk about it, and not just talk about Judge Garland and what happened to him, to sort of talk about this nominee and in these hearings. I can only say I do wish that Judge Garland got his chance to have a hearing, even if the Republican senators wanted to vote him down. I feel like if he'd been able to have the hearing, that would have been much better for the American people in the process.
Ed, same question to you. Were any norms violated? And I take it I know your answer. But even assuming so, should it have any impact on how Judge Gorsuch is handled?
Well, there have been some facts conspicuously missing from the discussion so far. One of those facts is that unlike the previous 4, indeed the previous 6 Supreme Court confirmations, last year it was the first time in a long time in which you had a president of one party making a nomination to a Senate controlled by the opposite party. That's exactly the configuration that's going to invite maximum conflict. When you add in that happened in an election year, when you add in that was Scalia's seat, when you add in that threatened to transform the court, it really should come as no surprise to anyone what happened. Indeed, I would argue that what happened has been baked into the process at least since 1992, when then Senate Judiciary Committee Chairman Joe Biden threatened exactly the same thing in a carefully prepared floor speech that he delivered, I believe, in June of 1992, basically saying that if a vacancy were to arise, President Bush should not make a nomination before the election. Again in 2007, mid-2007, some 15 or 16 months before the 2008 election, Chuck Schumer said that absent extraordinary circumstances, no vacancy that would arise would be filled. President Obama's former White House counsel, Kathy Rumler, has candidly acknowledged that if the situation had been reversed, she would have recommended exactly the strategy that Senate Republicans took. And I've got to think that would have been the obvious option, the lead option for any Democrats, again, if the situation had been reversed. Now, I want to distinguish between the argument that Elizabeth has made so far about constitutional norms and a much more expansive, aggressive, clearly wrong argument that some folks have made about a supposed constitutional duty. I'm not talking here about norms, which can be rather vague and can invite dispute over what exactly we're talking about. But there were some 350 law professors who signed a letter claiming that the Constitution requires the Senate to have a hearing and a timely vote on a Supreme Court nomination. A remarkable proposition. Now, I should say 350 law professors is a fraction of those who opposed Senator Sessions' confirmation. So it's as notable how many folks, I suppose, didn't join this and how many have made clear that they don't agree with it. But still, to have 350 law professors, including a couple luminaries, claim that the Constitution speaks to this question is really remarkable. If you look at the Appointments Clause of Article 2, Section 2, first of all, it governs the president. Secondly, it says simply that the president shall nominate and by and with the advice and consent of the Senate shall appoint a whole range of officers. All of the Senate confirmed officers are governed by the same Appointments Clause. So if you're going to make an argument about what the Senate's duty is here, you better be ready to apply it to all the officers under this Appointments Clause. Now, as it happens, this Appointments Clause says nothing about how the Senate shall exercise its role in the process, and indeed, the Constitution elsewhere confers plenary power on the Senate to make and follow its own rules. And we know that on thousands of occasions throughout Senate history, the Senate has killed nominees by inaction. Again, nominees who are subject to the same Appointments Clause includes a very small number of Supreme Court nominees. So I think the argument that some law professors have made and are still making, and that at least one senator, Jeff Merkley, is insisting on, that the Constitution imposes a duty here on senators is simply absurd. I don't know if anyone here wants to actually defend that argument, or whether we can assume that no one here is actually going to embrace that. Now, when it comes to norms, look, the Senate, the Constitution recognizes that the confirmation process is inherently political. As liberal law professor and confirmation expert Michael Gerhardt said recently, there are no rules here. Things are governed by politics. To be sure, there are practices that have developed over time, and I think we can all agree that in recent decades you've seen the clash intensify. And my modest point here is that you had a convergence of forces last year, including especially this Senate majority held by one party when the president of the opposite party was making a nomination, and including the election year, that fully explain what happened, and it really shouldn't be a surprise to anyone. Now, will this cast a shadow over what happens here? Look, this is a fully political process. It's therefore entirely proper for people to think that I don't like what happened politically last year, so I'm going to try to get some sort of payback this year. That's the nature of politics. I do think, though, that this stolen seat rhetoric is incendiary and irresponsible. It's some people have said that a Justice Gorsuch would be an illegitimate justice. Many folks are using the same sort of rhetoric that they decried candidate Trump for using. And I think we ought to be very careful before we descend into this sort of rhetoric. So look, if you want to make the case that you think that for political reasons the Republicans acted badly in not confirming Merrick Garland, and therefore there should be some sort of payback, it's open to you to make that argument. That's perfectly fine. I should emphasize I respect Merrick Garland. I have never said a bad thing about him. I have deep respect for his character. His one drawback is he's a judicial liberal and would have transformed the court. But I'm not going to say anything bad about Merrick Garland, the man or the judge. That said, the Republicans announced their strategy from the very beginning, and I do think that Merrick Garland would not have been nominated but for the announcement of that strategy in the first place. So I think that, frankly, once they did that too, it was impossible, once you adopt that strategy, to walk away from it. That would have been political suicide. And I think the strategy was the right one. Obviously, it paid off, or seems to have paid off bigger than most people expected. But in any event, I think it was entirely foreseeable, and I, again, dare say that Democrats would have done exactly the same thing, because this has been baked into the process now for 25 years.
Caroline, I see from your body language that there are roughly six things you'd like to respond
I have
to.
so many things I want to respond to. First of all, I think we need to put some actual facts on the table, real facts about what has happened. Ever since the Senate has been doing hearings, they held hearings for Supreme Court nominees since 1917. So to say that this was unprecedented not to give Merrick Garland a hearing is putting it mildly.
What about before?
You had
okay, but what about before 1916? Actually, there's a whole period.
Be irresponsible and incendiary, like Caroline.
Ed, you filibustered for 10 minutes, so now I get my chance.
Interesting word.
Before we have nuclear option up here. So but I actually would argue that what happened this past year and the immediate announcement by Senator McConnell that there would be no consideration of any nominee by President Obama put the court on track to have the most serious damage done to its reputation that has happened since the Bush v. Gore case. I think it was terribly destructive to constitutional norms, and we don't have to get into a discussion about whether there's an absolute dictate from the Constitution to have a hearing, but the fact of the matter is hearings have been held. The Senate has actually held hearings. The cost to Judge Garland is obviously great, but the cost to the country was so much greater. And the statements by the Republicans, and I think even Ed, when you say that it worked, I find that really, really troubling. It does really put, I think, even in an even more clear fashion, how politicized the Republicans made the court in that process. As you referred, this was the Scalia seat. Since when does a Supreme Court justice own a seat after he's passed? At which point do we say that the court needs to have a new person to replace the one who's passed and not determine that that should be a cookie-cutter replacement? I wonder why, when Justice Thurgood Marshall left the court, Clarence Thomas was actually his replacement. I wish we'd had a Marshall seat, but we didn't, because that's not how the process works. And I wonder if Justice Kennedy retires January 2nd of 2020, will we now say, oops, that's it? Sorry, that's for the American public to decide? We're not filling that seat? Well, that's just not how it's been done in the past. But I ask you, I would say, would you commit to that?
I'm happy to answer that, and I think there's been a lot of misunderstanding of the Senate Republican position last year, which again was dictated by the configuration of a Republican-held Senate and a Democratic president. So no, if
justices in presidential election years since the 1900s.
If there is a vacancy in the next election year with a Republican Senate and a Republican president, the clear response from me would be get moving.
So we don't lose sight of the actual nominee. I'm gonna pivot away from Garland, although clearly, there are strong views about the impact of that experience going forward. And there seems to be a consensus, at least, rightly or wrongly, that this is a deeply politicized process. At the same time, Shai, I'd like you to tell us what the criteria are that the Senate should be looking at. Do those include credentials, qualifications, and ideology, or just two of the three?
Clearly, credentials and qualifications. I don't think ideology in the sense of any sort of a litmus test trying to choose a Supreme Court justice who's going to rule a particular way. We're not trying to replicate Justice Scalia, nor are we trying to move the court in a different direction. I think you want to look at the body of work of the nominee and really assess the quality of that person's work, their legal abilities, their fair-mindedness, their commitment to law. And one of the nice things about Judge Gorsuch, for those of us who do these panels, is that if he's confirmed, we could have a lifetime of panels where we can quote his writings because he's so quotable. I know, Adam, you said you don't want canned speeches, but just to quote a little bit from what he's written recently in a tribute to Justice Scalia, he said, quote, "Perhaps the great project of Justice Scalia's career was to remind us of the differences between judges and legislators, to remind us that legislators may appeal to their own moral convictions and to claims about social utility to reshape the law as they think it should be in the future, but that judges should do none of those things in a democratic society. As Justice Scalia put it, if you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong." And I think, to me, that captures an ideology that everybody ought to agree that a Supreme Court justice should embody. And I think if you look at the body of Judge Gorsuch's work on the 10th Circuit, his work reflects that. He is a committed textualist. He's committed to the rule of law. There are absolutely cases in which he has reached results that would be described as conservative. no question. There are also cases where I think, I can't get into his head, but I think he probably didn't like the result that he reached. But that was where the law led him. And in that respect, I think he actually is a lot like Justice Scalia, for whom I could give similar examples. But there are numerous instances, happy to talk about some of them, in which Judge Gorsuch ruled against the government, in favor of individual defendants, in ways that perhaps, if you think about the facts of those cases, might not have been his preferred outcome.
Shai,
So
can I just say, you mentioned we shouldn't have a litmus test, but last year we saw both presidential candidates had a litmus test for the Supreme Court. I mean, it was a pretty stunning moment for me, because normally members and presidents are trying to say, there's no litmus test, we didn't ask any questions before we picked this person. Here you had two people running for office who were very upfront about their litmus tests. And so I'm just wondering what you think about the fact that candidate Trump and now President Trump has said he has a litmus test and he chose this nominee.
Well, so this may just reflect our different titles and jobs. Coming at this from the perspective of a private practice lawyer, I think we need 9 justices on the court. We need 9 justices on the court in large part because many of the cases that are decided by the court and that I litigate are not ones that would rise to the radar screen of anybody in the Senate. And when I say we, I guess I mean I. I'm looking for someone who can do law. And that, to me, is my litmus test. And I think that if you do that in some of these more mundane, technical, legal cases, that will also lead to good results in some of the bigger picture cases. But I'm thinking more of cases that lawyers like me deal with and less things that President Trump or
If I
Senator
could just
Clinton might
add
know about.
to Shay's list, I think, and because it sort of comes out of Christine's question, it's that one of the other important criteria is whether the nominee is independent. I think the litmus test language, was regularly repeated, gives, I think, the senators an important issue to explore in terms of whether and how the nominee was questioned on his positions, whether he made any commitments. And I think that's something that it raises so many questions, particularly after Sally Yates's firing and President Trump's attacks repeatedly on judges, to ensure that we have that is another part of the discussion.
Christine, when you seem critical of this notion that people are announcing litmus tests, are you saying that they're surfacing something that should be kept quiet, or it's something that didn't exist before?
I don't know if it ever existed before because I didn't work on the selection side of it, but my sensibility about the importance of the independence of the court has always supported this view that it isn't something you would brag about, and specifically on the campaign trail, both sides, this is not a partisan point, but both sides, I think for the first time, came out and expressed their litmus test to the roar of crowds. And I just think that is a change from where we've been before. And I agree with Shai, I'd rather there not be a litmus test. I don't think that is what people should be looking for when they're looking for to staff the independent branch of government, the branch that's supposed to be above politics. But I was saddened to see it last year.
Ed?
Well, I may be mistaken, and I don't have the facts at my fingertips, but I had thought that litmus tests had been pronounced long before, including by Bill Clinton, and I thought by Barack Obama. And as Adam's question suggests, whether or not they are announced, it's clear that they are applied in the selection process. So look, there is this inherently political process. It's built into the Constitution, and I don't think there's any way to get around that. Now, when we talk about how should the Senate act on a Supreme Court confirmation, I think you've seen over the years roughly 2 different models. One is the deference model, the notion that we simply look to see whether the nominee satisfies certain objective qualifications and maybe is not out of the mainstream, whatever that means. And if the candidate passes those tests, then he or she should be confirmed. The second looks more seriously at judicial philosophy. I think that if you look at the incentives that shape senatorial behavior, all other things being equal, senators on both sides would prefer the deference model because it basically enables them to go back to their constituents and say, oh, look what a reasonable senator I am. I voted for someone that the opposing president nominated. And that, I think, is why, even after the Bork and Thomas hearings, in 93 and 94, when I was a Senate Judiciary Committee staffer, the lead staffer handling the Ginsburg and Breyer nominations, you saw Republicans, roll over and play dead on Ginsburg and Breyer. Not because they ever expected Democrats to reciprocate, but because they saw this as in their narrow electoral self-interest. Now, what has happened in the meantime, happening first on the Democratic side with Bork, if not earlier, and then more recently on the Republican side, is the political bases of both parties have driven their senators to explore and oppose nominees based on judicial philosophy. It would have been unimaginable to anyone who looked at how Senate Republicans acted in 93 and 94 to think that they would have voted in significant numbers at all against the first Hispanic Supreme Court nominee. But that happened precisely because the underlying politics have shifted and senators can no longer play this deference game, which again I think is largely a self-serving game, though you can make institutional arguments based on limited competence of senators for the deference game as well. But I think we're well past a situation where senators of either party are going to be according much deference.
Just to maybe take the one opportunity to agree with Ed on this panel. Just kidding.
I'm looking up to see if the stopped clock is right.
It did. Well, it'll happen again tomorrow. I worked in the Senate as well, so I worked for Senator Daschle on judicial nominations, and it was a very, very different process, particularly for lower court judges, where we used to call it the bed check vote, right? The Monday night people would come back. I mean, there was district court judges, but even most of the appellate court judges. There were a few battles, but by and large, the transformation of the debate around judicial nominations has been profound in a fairly short time. And I think I guess I share with Christine some sense of the sadness about that, that it has become so political and so contentious. Maybe there's an important piece of the interest in understanding better the judicial philosophy of judges, and maybe the deferential model isn't a perfect one, but I think we've gone too far, perhaps, in that direction.
Yeah, I think I certainly share the hope that we could have a better world in the Senate confirmation process. But I wanted to echo, I think, a little bit of what Shai was getting at. And I think, again, it probably, as a Supreme Court litigator, this is how I think about my judges and justices that I appear before and file briefs in front of. And that's the reason why we don't like litmus tests. It's not just that it's, it might be indeed, and this is probably why people cheer when their candidates talk about using a litmus test. Sure, they do give you a sense of the way that person's nominee is going to vote on issues that you care about. The problem with using that for a judge is that we want our judges to be truly independent. We want them, again, even if this might be a little bit of a dance, but we certainly want to hold to this, I think, this notion that judges, even if they have a philosophy, take a case that comes before them as it comes. The facts of that case, the arguments made in that case, the precedent that exists when you get that case, and we want our judges, our justices, to rule based on that, not because they've guaranteed to vote in a certain way in order to get their name put forth. And I'm saying that generally about why litmus tests aren't something that I want to encourage, whether it's, again, we criticized candidate Clinton when she did that. We certainly have criticized President Trump for saying over and over and over that he had several explicit litmus tests. I think, to me, perhaps the most disturbing is that this person would be willing to automatically overrule Roe versus Wade when he or she gets on the court if nominated. So that's the problem with litmus tests. And certainly you want to look at a potential justice's record, philosophy, the way that he or she views the Constitution. I think that's incredibly important. And I, for one, would like to see more fulsome answers given during hearings. I think it's important, particularly in this case, where you have the context of having a president who has said over and over, I have these litmus tests. We do want to know whether or not, and it seems in some private conversations, Judge Gorsuch has indicated that he may not be quite as willing or eager to automatically overrule Roe versus Wade. So, squaring those two together, I think is really important. And I would like to see the hearing process, frankly, get a little more into a judge's philosophies on the Constitution, because I have a lot of questions about that as well.
Can I pick up for a moment on the question of judicial independence? Because I do think that for a president who I think values executive power, Judge Gorsuch is an interesting choice. And there are at least a couple of things about his record that suggest that, in fact, he really will be independent of the executive. One is he has seriously questioned the whole concept of Chevron deference. In recent administrations, I think both Republican and Democratic, the way in which presidents have wielded a lot of power is through agencies. And Judge Gorsuch has questioned the whole notion of deference to agencies on interpreting statutes. He's questioned the fiction that even Justice Scalia, I think, agreed with at certain points in his tenure, that Congress intended for agencies to fill in gaps in purportedly ambiguous statutes, as opposed to judges reading those statutes to mean what they say. And so he has called into question Chevron deference, and in that respect, potentially significantly limits the power of the executive. Second of all, there's one case I want to talk about briefly. It's a case he ruled on called United States versus Nichols, and it involved a federal law that makes sex offenders register and give notice before they move. And that statute gave the Attorney General very broad authority to specify, quote, specify the applicability of the requirements of the law. Essentially, that is a delegation of power to the Attorney General to make sweeping determinations about how the criminal code is going to govern hundreds of thousands of people. And Judge Gorsuch struck that down. He wrote that this statute would require the judiciary to endorse the notion that Congress may effectively pass off to the prosecutor the job of defining the very crime he's responsible for enforcing. And he did all of this to side with sex offenders, which he might well not have wanted to do. And so when I look at his record, I do see signs that give me a lot of comfort that this is a judge who is going to be independent-minded.
So, Elizabeth, why shouldn't we welcome in the Trump era someone who might be opposed to executive power?
Yeah, I think, I find this use of the Chevron jurisprudence of Judge Gorsuch as a support for he will be willing to be independent and stand up even to the president who put his name forward is a little bit odd because, we've already seen that, I would say, from the people that Trump has nominated to be the heads of his agencies, that he's not really interested in his agencies doing a lot, whether it's enforcing voting rights guarantees, the rights of transgender students, or providing for clean air and clean water through the EPA. So the fact that Gorsuch might not be deferential to particular Trump agency actions when he doesn't seem that keen on having the agencies do basically their job that they exist for, as in the Department of Justice, doesn't really give me a lot of comfort. What I am more interested in is he going to be an independent check when President Trump, for example, hypothetically, comes up with an unconstitutional, religiously discriminatory travel refugee ban? That's the kind of executive power that I'm more interested in, rather than this agency deference point, which I think in this particular instance is not a particularly good evidence that he would be willing to stand up even to the president to put his name forward. But even generally, I think that a lot of conservatives view getting rid of the Chevron doctrine as part of a much broader plan to dismantle the administrative state. So given that progressives are generally more in favor of the work that has been done from the New Deal forward to guarantee, make sure that the guarantees of equal protection and equality and justice and civil rights in this country are a reality, in addition to all the other social safety net aspects of healthcare and environmental protection, that doesn't give me a lot of comfort.
Well, I'm not following your argument. I mean, I've understood that the academic view, at least, of Chevron deference has not been intensely ideological, that there have been critics of Chevron deference across the board, just as there have been supporters. And again, what you'd be talking about here, or how Chevron plays out in practice, depends on who is running the agencies. And if you're going to be looking at agency action one way or another, it's not, the White House isn't going to be doing things. It's going to be through agency action. So I'm not sure why you don't see Judge Gorsuch's skepticism of Chevron as a plus.
I want
Can I just add one thing?
Yeah.
You had asked, the question was actually about qualifications or what criteria. And I think an important part of that has been judicial temperament. For as long as I served Senator Leahy on the Senate Judiciary Committee, they talked about judicial temperament, a portion of which has to do with, are they seeking to overturn settled law, respect for precedent? And in that particular case that I think will be talked about a lot, the Chevron deference concurrence, I think that there, it is certainly something that I think senators will want to explore. Is he trying to dismantle an area of law that has existed for decades? And that goes to whether he has the temperament they want to see in a judge. What kind of agenda does he bring? And when you have the president's chief of staff saying last week that this nominee shares the vision of Donald Trump, I would imagine that people are going to want to ask, what does that mean exactly?
So, Christine, if a nominee indicated skepticism of Citizens United, would you have the same concern about judicial temperament? I mean, I think we're trying to shoehorn all this into judicial temperament. That's not what judicial temperament is. It's the ability to dispassionately listen to and weigh arguments and not indulge your own policy preferences. I invite all of you to read Judge Gorsuch's concurring opinion in, I believe is it Gonzalez-Brizuela? You see that this is an immigration case where the immediate consequence of the view that he's advocating is in favor of the applicants for immigration relief. But beyond that, what you see is not someone who's trying to impose his own policy preferences. What you see is a serious discussion of first principles of separation of powers. So the idea that this concurrence raises concerns about judicial temperament strikes me as entirely backwards.
I mean, I'll tell you that both Republican chairman and Democratic chairman have raised judicial temperament. It was certainly raised when Sotomayor was the nominee. It was certainly raised when then Chairman Specter asked John Roberts and Samuel Alito about super precedent and super duper precedent. So it was.
It's not the only definition of temperament, and it strikes me as a slightly unusual one. But let's return to it in a second. Let me see if I can clear away some underbrush. Not long before Justice Scalia died, Chief Justice Roberts gave a talk up in Boston, and he expressed dismay that his three most recent colleagues, Alito, Sotomayor, and Kagan, had gotten a lot of votes against them because they had, all of them, he said, been qualified. And that's all the Senate should care about, are people qualified? And I think what he meant by qualified is, are they able lawyers? And I just want to ask the group generally, under that definition of qualified, does Judge Gorsuch, graduate of Columbia, Harvard Law School, doctorate of legal philosophy at Oxford, is he qualified in that sense?
Well, I'd just say if that were one of the major issues to consider, we would have Justice Garland. So, I'd embrace it. I think that's gone by the wayside, though, because that clearly was not what was considered by the Senate last year when President Obama nominated Merrick Garland.
So Garland was qualified. You're not saying Gorsuch is unqualified. You're saying that that's not the only criterion we're looking at anymore. What are the other criteria we should be looking at?
Well, I mean, I think he's certainly well credentialed. I don't think any of us is going to say that he doesn't have an impressive resume in terms of credentials. Obviously, that's true. I think that what we were talking about a little bit more in the beginning of this discussion about what we're looking for in a judge, and in some ways comes into play. I want a judge or justice to be someone who is going to be faithful to the law and to the Constitution, and not be there to pursue a particular political agenda. I think that's true whether it's a justice who is appointed by a Democratic president or a Republican president. I understand that elections have consequences. And so there is going to be perhaps if there's a conservative president and puts up someone who is a more conservative justice, it might not be exactly the person that I, as a progressive, might want to put forth. But you still, I believe, always want to make sure that that particular nominee is someone who's going to follow the law and Constitution. So, for example, what I have been looking at, and I will note that Constitutional Accountability Center does not take positions on nominees generally until after, judicial nominees until after the Senate Judiciary Committee hearing. So we have not taken a position on Judge Gorsuch at this point. But we are concerned looking at his much touted claim to be an originalist, whether he is someone who is going to be as faithful to all parts of the Constitution, including the amendments that were passed after the Civil War that greatly expanded federal authority to guarantee equality, guaranteed the right to vote free from discrimination on the basis of race, gender, and then with the poll tax amendment, I believe, on the basis of economic status. So that's what we're looking at, and I want a justice of either ideological bent, conservative, liberal, libertarian, to be someone who's going to be doing that. And I think with Judge Gorsuch, particularly given that he's been touted as an originalist, we want to be sure that his philosophy of the Constitution is to follow all of the Constitution and not just perhaps those particular parts of it that match his political agenda. And I would say that that's something that holds true for either candidate. Now, I've made a very reasonable argument, Ed, so don't go around pretending it's someone else's argument just so you can knock it down. Mine is very reasonable.
She wants a very robust originalist. You don't have a problem with that.
Well, look, I think Elizabeth's general point is one I agree with. So maybe we disagree.
Let's be praised.
Maybe we disagree on what her general point is. But look, when she
very,
said,
very clever, Ed.
but look, when she says that we want someone who's faithful to the Constitution, that question inevitably implicates fundamental questions of judicial philosophy, as her own follow-on comments, I think, quite clearly indicated. So.
Although I don't think it's a judicial philosophy to believe that the amendments to the Constitution are just as much a part of the Constitution as what was written in 1789.
Of course not. No, I certainly agree with that part of your point as well. So, look, under the deference model that senators at times use, you don't even need to look at these. But it's entirely reasonable under this other model for senators to vote based on whether or not they believe the nominee has a sound judicial philosophy. And that can involve, at the highest level, originalism versus the living Constitution. It can involve subsidiary methodologies within originalism. But once you move away from the deference model, how can you fault senators from taking into account judicial philosophy? And indeed, there's a lot to talk before about litmus tests, much of which I agree with, but insofar as a litmus test is a good proxy for judicial philosophy, rather than simply a statement of a result you want in a particular case or political preferences, then it serves a useful role there. And again, I think everyone has always looked to such measures, whether or not they acknowledge it.
So I'm going to have this happen twice. I'm going to agree with Ed again. So twice in one evening, pretty excellent. And I would say that we have moved away from that deferential approach. And so I think that means that the Senate and the Senate Judiciary Committee particularly has to spend a lot of time with this nominee and in looking into his judicial philosophy and his voluminous record, thousands of decisions in which he's participated in some way. And, and there are a lot of very important questions. And, I'm just going to highlight one that I hope the senators will pursue, which is in the Hobby Lobby case, in a concurrence in the 10th Circuit decision where he talks about how understanding religious belief means that people can't be expected to have what he called complicity in the wrongdoing of others. And, I think it's a very important question for the senators to explore. What does that mean, and how far does that go? To what extent do people with religious beliefs, how do they have to follow the law if they believe it violates their conscience? Does that come into play around LGBTQ issues, around race, public accommodations? What is the outer limit of that? I think that's a really important and potentially very frightening direction for the law to go.
Well, this is exactly, his views there are exactly what Supreme Court precedent has said, going back to Thomas v. Review Board, if not earlier. The basic concept is that it is the individual himself or herself who defines what his religious beliefs are. No one says that religious beliefs are an absolute trump. That's not what the Religious Freedom Restoration Act says. But in terms of whether, how one defines what illicit complicity is, again, there's a sincerity test. But beyond that, you don't have federal judges or bureaucrats deciding whether someone has an approved religious view or not.
So, Christine, we've been hearing some questions people might like to pose to Judge Gorsuch. What's been your experience watching confirmation hearings about whether it's possible to elicit valuable information from judicial nominees?
Wow, that's a tough question. Is it possible to elicit meaningful information?
Valuable, meaningful, you choose the adjective.
I do think that Sandra Day O'Connor might have been the first, when she was in front of the committee, to basically say, I'm not going to commit on any issue. And so there is a dance. I do think the Senate has to respect the fact that a future Supreme Court justice should not be making predictions on any given case. But what they do need to answer to is what they have done in their past, right? So I do think that many of the cases being discussed here will be explored. And so certainly you could imagine cases on the Chevron deference case or the Hobby Lobby decision. And I do think that it is not like a typical interrogation if it were a trial where you can get, a yes or no answer. It's not like a political debate, raise your hand, if you believe in a full, robust Second Amendment. It's not that kind of theater. Because senators do have to understand that the person in front of you needs to, not have committed on every issue. So I think it's a challenge. But I do think that you can learn about how they approach it. I think a lot of the things that Shai mentioned earlier, I'm sure will appear in the nominee's opening statement, right? Everyone wants to hear a future justice talk about, I don't do what I want to do, I do where the law leads me. But some senators are better at others at trying to figure out, do you have a vision? Do you have an agenda? What are you trying to achieve with this concurrence when you already agreed in the result? And I think you'll hear questions of that sort.
Okay. One line of attack I hear a lot of when people reach out to me about Judge Gorsuch is that he's too friendly to big business. He sides with the big guy. Is that something, Elizabeth or Carolyn, you guys have explored?
Yeah,
What did you find?
So we've definitely been looking at this. The Constitutional Accountability Center has done this project over the last several years that looks at, going back to the Burger Court, the way that the modern era Supreme Court has sided with business over the interests of average working Americans. And the Roberts Court is the most pro-business court of the modern era. You can find all of the information on our website at theusconstitution.org, but we use the Chamber of Commerce's participation as a proxy for that particular indication of pro-corporate interest bent. And, we certainly are concerned that Judge Gorsuch might be someone who further entrenches that tendency of the Roberts Court to back the interests of big business and corporations over the little guy, the workers who come in who have, there's the frozen trucker case that a lot of people have talked about, which I feel like is a somewhat unfortunate label for a case that is really serious. There was a truck driver who was in freezing conditions in a very unsafe environment, and Judge Gorsuch, I think, read the statute in a way that I don't think Chief Justice Roberts would have suggested a statute should be read in King versus Burwell. Again, we have some concerns about whether or not Judge Gorsuch would entrench that pro-business bent. I think perhaps only heightened by the fact that the business community has been positively gleeful about his nomination and the fact that they see his nomination and potential ascendance to the bench to be something that would be incredibly good for their business clients and incredibly good for business. Now, obviously, there are going to be some times when businesses should prevail. I'm not saying that. Obviously, there are cases where that will be true. But when there is a tendency to stretch statutes, particularly, I would say in the arbitration context is where we've seen some of the most egregious examples in the Roberts Court to favor big business over average working Americans. That is definitely something that's concerning to us.
Well,
Can I just add a footnote to what Elizabeth had to say, which around the frozen trucker case? It's a Trans Am case, but I think it is very important to know that even in the context of employment cases, Judge Gorsuch has ruled decidedly in favor of employers, repeatedly denying workers' rights, splitting decisions, even often with Republican judges. And I'd say in this particular case, what was particularly disturbing is I think for a textualist to pretty much dismiss the text of the statute, and I'll quote, he talks about health and safety. He says the terms in the statute are ephemeral and generic. Basically, ignore that. That's not important. So I think it's a significant issue. Again, something I think that I hope the senators will spend some time examining how much of a textualist he really is.
Well, let me address some of this. First of all, if Elizabeth were right that the Roberts Court is the most pro-business court, then it would hardly be surprising that a lower court judge faithfully applying Supreme Court precedent would be ruling in favor of business a fair amount. Second, I have answered case after case that folks on the left have raised. I haven't seen anything yet that has been substantial. This frozen truckers case.
Notably, we haven't published our reports yet. So
Yes.
just wait.
Yes, holding your ammunition.
Yet.
Holding your ammunition. This frozen truckers case, I don't have it in front of me right now, but the trucker who was fired sued under a whistleblower statute. Pardon me if I don't get this exactly right here, but you haven't heard anything yet that actually relates to the text of the law. This was a statute that said that if you are ordered to operate your truck in a way that is unsafe, you have some sort of relief available. Well, he did not operate his truck. He abandoned his truck after, by the way, failing to fuel it with gas, pulling over in a way that caused the brakes to freeze up. Look, it may well be, as Judge Gorsuch says, that this person shouldn't have been fired. But to read this whistleblower statute as though it's the equivalent of enabling the particular body here to micromanage every hiring and firing decision is quite something. So I think if you look at his opinion there, I invite you to do that, you'll see a very careful textualist analysis.
I just have to say one thing, which is that the judges who didn't agree with Judge Gorsuch pointed out that operate, if you look in the dictionary, it does in one definition mean drive, but in another definition it means control the functioning of. In which case, and as well as precedent dictated that this driver should be able to not lose his feet to frostbite and not lose his job at the same time.
Well, you spoke of judges. It was a 2-to-1 ruling with a single judge in dissent.
So I feel like the odd one out here because I haven't read the Frozen Truckers case. I will go look at that. I'll say that as somebody who litigates business cases before the Roberts Court and before the lower court, it's not always that easy to win them. And so in that respect, I somewhat question the notion that this is any sort of a reflexively pro-business court. I think what we really want in a judge is somebody who isn't reflexively pro-business, but who also is not going to read the statute differently because the facts of the case may be very sympathetic to one side or the other. And I think most judges probably don't have a huge warm spot in their hearts for businesses. I think a lot of people might very well be sympathetic as they probably should be, to the sort of facts you're describing in the frozen trucker case. But what we ultimately want is somebody who's going to be able to disengage from that rather than factoring that into the equation and give the text what they think is its fairest reading. I also think, and again, this may just be my perspective given what I do for a living, but the way our laws are made, a lot of them, while they are designed to protect workers in certain situations, are going to take into account serious business concerns because those interests are represented in Congress and are considered by the president. So we have laws that in these situations are not completely one-sided, that have to be given the best textual reading. And I think what we want in a judge is somebody who, even in a very sympathetic sounding case like frozen truckers, is not going to let that sway them from what they think is the right reading of the statute.
I want to turn to your questions in 10 minutes or so, but first I want to quick cover two forward-looking topics. One is, what's going to happen on the Gorsuch nomination? Is there any prospect this nomination gets defeated?
Well, my own take is that Democrats need to figure out how they want to lose it. And it's actually a very important strategic decision. And I think they're struggling with this now. One question is whether they decide to try to filibuster, in which case they could trigger abolition of the filibuster, making it so much easier for President Trump to fill any later vacancies. This is the path that I hope is taken. So they have the alternative, of course, is to not filibuster and let a handful of their very vulnerable red state Democrats vote for Judge Gorsuch, maybe try to keep the margin below 60 so it sort of seems like a filibuster threat for the next time around. But again, I think they're really struggling with this. You see, looking at the statements, a lot of dissent, I think, within the ranks. I think how Judge Gorsuch does at the hearing, how likable he appears, how appealing, will have a real impact on which way Senate Democrats go. But again, they face the challenge that their best option and their worst option both involve going down the same road for a distance, that is a filibuster road, and then diverging.
Caroline, is that right? The choices are how to lose?
Well, I mean, it's certainly a challenge. I mean, I think historically, filibusters of Supreme Court nominees are practically non-existent in any way that is sustainable. I think there will be a 60-vote margin required, and I think there will be a lengthy debate. Whether the Democrats will decide to extend their filibuster long enough to provoke a nuclear option, I agree with Ed that I think they're wrestling with that right now, though Christine may be closer to all this than the rest of us.
So I should just be clear that I have not worked at all on this nomination specifically, but based on the ones I have worked on, I think it's too early to make that determination. What happens in this phase in the process is document production. It doesn't just happen at law firms. It happens in the Senate Judiciary Committee. The nominee submitted a questionnaire and then had to submit an amended questionnaire, and I think is probably in the process of amending it further. The chair and ranking have requested additional documents that were not covered in the Senate questionnaire that he filled out, specifically relating to his time at the Justice Department. So, and I know about this from press reports. And then there was a recent follow-up by the ranking member, specifically also related to his time at the Justice Department. So the chair and ranking have sent a letter to the Bush Presidential Library. They've also sent letters to Attorney General Sessions, because in the questionnaire, the nominee didn't really explain what cases he was working on while he was a principal deputy in the Associate Attorney General's office. So I don't know what the end game is, but I'll just tell you at this point in the process, there's a lot still unknown. And then the hearings itself, there's some unpredictability about how they go. And I think anyone trying to game it out before then is diminishing how important those two things are. If you give people a process argument to oppose someone, they're more likely to oppose them. So if there are things not provided, or if people feel jammed, senators don't respond well to that. So I think that the process things that happen before the hearing and as part of the debate will shape what happens in terms of the votes.
Do the one-on-one courtesy calls the nominee makes to just about every senator make a lick of difference?
I mean, I think senators are real people, and they respond to the real person nominee in front of them, and that might explain why several people refused to meet with Merrick Garland.
I'm sorry. I agree with you. I think, look, senators become senators in part because they like to be liked by people. Some of them actually like people as well. And so it's more difficult to speak harshly about someone with whom you've had a pleasant conversation and it seems like a decent guy, and maybe he held your dog, as I think happened with one of the senators, or you met his family. So I do think, Adam, that at some level these meetings make it, depending how they go, but can cut in favor of the nominee.
Yes, Elizabeth.
Yeah, I think as a description of human nature and the way the process works, I'm sure that's true. But we're not going through, the guy you want to have a beer with, or, in Gorsuch's case, the person you most want to ski down, a double black diamond with. I might pick him for that. But, so I think that the likability question is something that is going to come up probably a lot in the hearing. He is someone who people like. But that's not really the point. I really like Ed. You might be surprised by that. Against all odds, I do really like Ed. I'm not sure that I would support him for a Supreme Court justice, although I won't tell you till after your hearing. Okay. So, we'll have to wait in suspense. But so that's not really the point. And, but it does end up being something that people talk about a lot. And I think perhaps that's probably why, in addition to not wanting to meet with Judge Garland, probably a lot of people really did not want to have a hearing for Judge Garland because, he is one of the nicest people you'd ever meet. And, but so I think that's just not the right thing, even though it is something that people will focus on a lot.
So I agree that likability isn't the point. I do think, though, that one thing that you can gauge by talking to somebody, and particularly by talking to them about legal issues, is, are they a good listener? Are they willing to consider what you're saying? Do they respond to your ideas respectfully? And that's something that I think is important, not only for the lawyers who have the experience of arguing before a judge, but also because of what it does say about the person's open-mindedness and independence. And I would hope that the process before the Senate is geared not towards just figuring out, is this someone you'd like to have a beer with, but is this someone who you think is going to be a good judge in that respect? And I think Judge Gorsuch will impress in that way, but that's what we'll see.
So you're suggesting that they're determining whether the nominee has empathy?
Open-mindedness is very different from empathy.
But I think, look, this is a political process, and whether or not a particular senator values likability itself in the process, he's going to be factoring in how this nominee will play publicly so that he or she can sort out the political costs of support or opposition. So, I think affability, how one comes across publicly, is inevitably a significant part of the confirmation process.
So now, there is at least a school of thought that Judge Gorsuch, if he succeeds, replaces Scalia, conservative for conservative. Fundamental dynamic on the court doesn't change, and that the big change, if there is one, is if one of the three older justices, Kennedy, Ginsburg, or Breyer, retires. And so my last question before we turn to the audience, and this is to help my summer travel planning, are we going to have another vacancy?
No.
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 Thank you. Okay, well, I've been on the horn with the travel agent.
This year, you mean?
June, yeah.
Oh. I would say probably not, but I wasn't sure whether Donald Trump at the State of the Union, or whatever we call it, the speech last night, was offering an ambassadorship to Justice Kennedy.
And it sure seems that every shortlist now is composed only of Kennedy clerks.
Well, I think any actual shortlist includes other folks.
All right. I'm sure you have, we've covered a lot of territory. I'm sure you have questions for the panelists. Yeah, well, and there are microphones if you don't mind standing up.
Hi, can you hear me? Okay. Thank you, Adam, for picking on me. My name is Hana. This is Sorcha. As young women, we're actually members of NARE also. Hi, Caroline. As young women, we're actually, I'm sure as you know, very concerned about our individual liberties and reproductive freedom, especially keeping in mind Judge Gorsuch's defense of Hobby Lobby. So to Elizabeth's point, about independent ruling when religion and even privacy are at stake, how can we believe that Judge Gorsuch will truly be an independent justice?
Thank you for your question. I think that that's certainly something that needs to be addressed at the hearing because, specific to your questions, 2 of the at least 3 litmus tests that Trump repeated over and over. One was being willing to overturn Roe versus Wade. The second was to have a view of religious liberty that, as Trump said in one interview, would represent Christians fairly. Obviously we don't want our justices on the bench to represent anyone other than representing the law and the Constitution. And certainly people of all faiths or no faith have constitutional rights, and that should be vindicated by justices on the Supreme Court. So, look, Judge Gorsuch is his own man, but the context in which he was nominated raises really serious questions when you have these particular litmus tests stated in the way that Donald Trump said them. So I think that there are real serious questions about that I hope are addressed at the hearings.
So I'd just like to follow up on that. And I think Judge Gorsuch himself has not ruled on abortion directly, but he has said a few things about the Casey decision that I think will be explored in the hearing, at least I hope so, where he suggests that Casey isn't a sort of a robust affirmation of Roe, but instead is really just stare decisis. When in fact there was quite a lot of discussion about women's autonomy and liberty interests in that decision. But I think by reading it narrowly, it makes it less potent, gives it less of a strong constitutional foundation. And so I think that's an area where I really hope the senators will, that they will explore, because I think that certainly, from my point of view, would be extraordinarily negative direction for the law to go.
Well, I seem to be hearing lots of litmus tests from people opposing litmus tests. It just seems that the real objection is to litmus tests that particular litmus tests they don't like. I may have missed part of your question, but I think Judge Gorsuch's position in Hobby Lobby was plainly correct. I'm not relying simply on the fact that the Supreme Court affirmed it by a 5-4 vote, actually 7-2 on the question of whether corporations or persons capable of exercising religious liberty under the Religious Freedom Restoration Act. But I believe that the analysis in that majority opinion is clearly textually faithful to the Religious Freedom Restoration Act, and it's only the particular context in which this controversy arose that has caused people to, I think, some people take a distorted view of that. So I see nothing in his record that raises any concerns about his independence, which, of course, we don't want judges, which we shouldn't want judges or justices who are independent of the Constitution. We're talking about folks instead who judge read the laws neutrally and independent of political considerations. And again, I think his record demonstrates that he is a judge like that.
Yes, sir.
So Mr. Whelan just sort of foreshadowed my question, which was, and on the subject of Casey, this discussion of litmus tests remind me of 2 specific opinions, the opinion of Justice Blackmun and the opinion of Justice Scalia in Planned Parenthood versus Casey, where Justice Blackmun essentially more or less called for consideration of things like litmus tests by invoking the fact that he was about to retire and that he hopes that his replacement is someone who would defend the right to abortion. And as Justice Scalia pointed out, the court more or less gets left alone by political considerations when people presume that the court is doing lawyers' work. But when it's deciding these very massive questions of public policy that don't have clear a nexus to the text of the Constitution, it becomes the very political battle that it is, as we saw with Judge Bork and Judge Thomas at the time. So for the people who are opposing litmus tests currently, That doesn't seem to be the traditional position of certainly people who defend those decisions. So I'm curious as to why your views now about litmus tests are what they are. Thank you.
Well, I think my views on litmus tests personally have always remained the same. So, I can't speak for anyone else, or certainly the way that someone might have said it in their own views. Clearly some people, as we saw from the fact that candidates of both parties talked about litmus tests. I will say, with respect to your question about particular context of Casey, part of the reason that I object to Ed's characterization of us wanting a litmus test that just is something that goes our way instead of the way that we disagree with. I assume he's talking about upholding Roe versus Wade versus striking it down, is that I want a justice to follow the Constitution. And when I and my colleagues look at the text and history of the Constitution, and we filed briefs to this effect in the Supreme Court, including in last term's abortion trap law case, we think that there is clearly, protected by the Constitution, a right for a woman to choose whether or not to have an abortion. That doesn't mean that certainly there can't be people who say that they would advocate against abortion, but I think that you cannot say that it's not protected in the Constitution. That's not a litmus test. I just think that's the way that the Constitution's text and history points us to. So, I wouldn't want someone to do anything other than follow the Constitution in that case, but I clearly disagree with Ed and many others, I'm sure, on what the Constitution says in that case. But that's why I feel that particular way. I think that there is a very strong nexus to the Constitution, indeed, that the text and history of the 14th Amendment in particular, as we argued in our brief in Whole Women's Health, requires that.
The biggest factor, I think, in the escalation of the judicial confirmation wars in recent decades has been Roe and its continued existence. Obviously, there are other cases too, and look, folks on both sides are going to see certain cases that they object to on the other side, and that they may be right, or it's human nature, obviously, to take more offense at the other side's perceived wrongdoings than at one's own. But if you're really interested in lowering the temperature for judicial confirmations in the long run, what you ought to want is for Donald Trump to get 3 more vacancies after this one. Get Roe put into, what's the left's phrase, the dustbin of history. Restore it to the political processes where the matter belongs, and move on from there.
Yes.
So in recent days, we've seen some questions about deference to the judiciary. We started to see it during the Trump campaign with the questioning of a federal judge being able to be impartial in a case because of his heritage, and we've continued to see some signs. And Chief Justice Roberts, I guess we're a dozen years, is that right, Adam, into the Roberts Court. And Chief Justice Roberts has said repeatedly that what a miracle the rule of law is, and how important it is to him to carry on that legacy, where we don't have martial law in the streets, right? Where people actually listen to judges and do what judges say they have to do even when they disagree. And I guess my question is that in this situation where we had a purely political fight over an otherwise qualified nominee, who never was even given a chance to have a hearing, and now we have another nominee who's very different in many respects, why should the public trust the judiciary? Why should the public, even if we say it's one step removed, even if Judge Gorsuch could be fair and impartial, why should the public trust the judiciary because of the way the politicians are using the judiciary as a puppet?
Well, look, I think abstracting from the particular situation, this is a tension that inheres in the Constitution. You have a inevitably political method of selecting judges, yet we expect the people selected by that method, who are often, say, fundraisers for senators or others, we expect them to be above and beyond politics. Traditionally, the best guarantee of that has been the traditional understanding of judging as itself distinct from politics, as not involving looking to what's in your heart to decide what the law means, as President Obama's notorious empathy standard stated, but instead to understand that the judicial craft is an intellectual discipline, that there are rules that apply to that, and that once you move from lawyer to judge, you're engaged in a very different enterprise. What has happened in recent decades is the collapse of this understanding of the role of judging. And this collapse has been abetted by law schools throughout the country, including this one. And it's very, very difficult when you have that collapse.
Well, Ed, respectfully, do you think the public ever truly understands, the general public ever truly understands the judiciary as an independent, non-political branch? What they really see are the politicians pushing these judicial
Well,
candidates.
if I could just jump in here, one, and we could spend a whole nother panel, maybe Dory can organize this, talking about how political originalism is and textualism and how self-serving it is. In any case,
That's a good panel
but
title.
for most judges, this doesn't really. I mean, most of the judiciary isn't selected in such a public or political way. And I think Christine and even Ed and I, who all worked in the Senate, saw a lot of different proceedings and the way that senators engage with the White House and the selection process that they go through in the states. A lot of judges are coming off the state courts or were magistrates, and there is much less politicization. There's more than there used to be, unfortunately. But I think as a result, I think most people's experience, except for the one time every several years when there's a Supreme Court vacancy, is with judges in their normal kind of situation who are not enveloped in that situation. So I think that's why people tend to continue to have some greater respect for the judiciary than the political branches. So I think it's been eroded. I think last year really did erode it. I think the obstruction in the Senate was a very damaging episode.
And I think your question is a good one. The public's confidence in the third branch to be independent affects their ability to serve its function under the constitutional democracy, right? So your point is a very good one in terms of making sure the American people understand the importance of it. And it also explains why people were so dismayed at attacking a sitting federal judge for his ethnicity.
Well, let me follow up on that point, because that's an interesting point also. President Trump said some fairly harsh things during the campaign about Judge Curiel and then about the judges involved in the travel ban case. And there was a sense in which it seemed that Judge Gorsuch was distancing himself from those remarks. And then there was some question about whether the distance was adequate. Is that a topic that ought to be explored further?
Oh, I'm sure it will be. And obviously, senators can raise whatever questions they want. And I'm guessing that that's going to be one that will be common.
And what answer would you hope he gives?
Well, what's the exact phrasing of the question? Look. I think that
The president who nominated you seems to launch personal attacks on judges with whose opinions he disagrees. Is that a good way to run a system?
Okay. Well, as someone who's criticized then candidate and President Trump's statements about judges, I regret that he's made those. Look, I think it's important to distinguish judicial independence from judicial supremacy. I do not think that judges are beyond criticism. I don't think that, but I do think it's important that especially members of the executive branch and the legislative branch, when they engage in criticism, do so responsibly and carefully. I don't think Twitter is particularly well suited to the sort of criticism that's called for. I think there ought to be respectful consideration of the judge's opinions, which again, after respectful consideration, it may be fine to say this is all wrong. I doubt very much that the particular manner in which it was handled was designed to be very effective. So I have my real concerns there. Look, I would hope that Judge Gorsuch would say both that that judicial rulings shouldn't be made political footballs for no reason at all, but also that judges and their rulings are not beyond criticism.
Well, but the criticism was based on the fact that this particular Judge Curiel, his parents had come from Mexico. And
I'm not defending that at all.
I'm just saying,
Yeah.
it's beyond,
Yes.
it's
Yes.
certainly criticizing somebody's rulings. If you disagree with the basis on which they ruled, that's one thing. To say that they're incompetent to rule because of their ethnicity, I think, just took it so beyond what we have seen in political discourse that I think was pretty shocking to most of us.
I see two more questioners, and we have time for two more questions. You're first.
So my question is actually related to that, so excellent segue. But, in response to the things that Trump tweeted about Judge Robart, Judge Gorsuch then said, it's disheartening and, demoralizing. Did you feel that that was actually a display of his judicial independence? There are other people who are saying, maybe it's sort of staged so that it gives cover to Democratic senators to vote for him and say, well, look, he's independent because he was able to criticize President Trump. So I'm just sort of interested in whether the panel thinks that that was a real display of independence or if that was sort of just an act of cover.
I think, Christine, you said earlier, was it you who said you can't get inside his head? Who knows? Certainly a question that has been raised, but I don't know what the basis would be for that.
I mean, I think that is something that, to, I guess, bring both questions together, should be addressed at the hearing. I do think it's appropriate to, ask. Adam did a very nice formulation of the question that could be asked, because you're right, those reports came out, and then there seemed to be some contrary statement from Gorsuch's Sherpa that he wasn't talking about those specific comments, but that any criticism of the bench is disheartening. So, I think that's why it's something that I would really like to hear him give a, vigorous defense of the impartial, fair, independent judiciary at his hearing. And, there have been some suggestions, I think, again, by Kelly Ayotte, that it's improper for a judge to comment on those statements that threaten the independence and of the federal judiciary because of the canon of conduct for lower court judges, doesn't apply to Supreme Court justices, to not comment or not to engage in political activity. Well, first, I don't think that an independent, fair, impartial judiciary should be considered a political question. And if you do, then I have some concerns about that. And even more to the point, the first canon of judicial conduct is to, through your own actions, promote the public confidence in a fair, impartial, independent judiciary. So I don't find that a reason to not engage with that question at the hearing, and I, in fact, hope that it is something that will be discussed there.
I have a feeling that in the mock hearings, the so-called murder boards, Judge Gorsuch is, even as we speak, formulating the correct answer to this question.
But I'll just say, look, you can look at virtually any answer any Supreme Court nominee has given in the last several decades and ask, well, was that really sincere, or was that just simply designed to advance confirmation? How are you ever going to parse that? I just think it's an unanswerable question.
All right, let's take one last question.
My question relates to the increased politicization of the nomination process. Mr. Whelan, earlier today you expressed sympathy, at least, if not outright glee, at the possibility of the nuclear option being deployed and multiple justices being confirmed and tipping the balance of the court. But I'm wondering if you have any trepidation about what the next stage in that process might look like. There's a lot of debate that's been had here today about whether or not the long-term filibuster and the refusal to have hearings for Merrick Garland was unprecedented, but that's how Democrats have interpreted it. What might happen if, say, the filibuster is eliminated for Supreme Court nominees and in 2020 Democrats regain complete control of the government and court pack a la FDR? Is that something that you personally feel worried about, or that there's any concern about among Senate Republicans or among conservatives or among everyone about what this process might continue to look like if it continues to escalate?
Well, let me try to answer that question. And it's a bit complicated. I mean, in one respect, if you actually are interested in getting confirmations moving as quickly as possible, you want to get rid of the filibuster, because a filibuster is a minority tool that can block confirmations. And again, when Senate Democrats eliminated the filibuster for lower court nominees and for executive branch nominees in November 2013, newspapers reported at the time that the only reason they didn't do it for Supreme Court nominees is because the abortion group said, don't do it now. Let's wait until we're in the middle of a battle and we know that this will actually benefit us. It could redound to our detriment. Now, you asked the question, am I concerned that, that if the filibuster disappears, that it will help a future Democratic president with a majority Democratic Senate? The short answer to that is no. I'm happy to. Obviously, the rule would play the same under that situation. I would say to my conservative friends that Senate Republicans will never filibuster. Let me put it slightly differently. No Democratic president will ever nominate someone who is so politically toxic that Senate Republicans would ever dream of filibustering that nominee. It simply won't happen. You're not going to have the next Democratic president nominate Lena Dunham when he or she could get exactly the same thing by any of dozens of objectively qualified candidates with views on the issues that may not differ very much.
If I may, but what about escalation? What about the 9 justices on the court that's not constitutionally prescribed? What about if the next Democratic president went full FDR?
Oh, okay. Well, that's a good question. Look, I think that that escalation is as likely as to happen, and whatever percentage that is, irrespective of what happens with the filibuster in this context.
All right. Thank you. Please join me in please let me introduce Dory to you.
I just want to thank all of you because this was a really interesting and delightful program.